Good morning, haters. Welcome to another episode of I Hate Real Estate with my good buddy, Kendall Grooms. How are you?
Good. How are you?
I'm okay. How was your weekend?
It was good.
Anything interesting happen?
No, it was my sister-in-law's birthday, so we had a little birthday party.
Did you have cake?
Yes.
Did you eat it too?
I did.
That it worked out well for you. That's good. You had your cake and ate it too. I asked you this morning if there was any golf. So in Arkansas, it's freezing. It's 30 degrees outside, so
There
there's
was
no
golf.
There was football.
Yeah,
Did people win games and stuff?
I think so.
Yeah, I've lost track of football. I've given up.
Once college ended, I was done.
Oh, there you go. Okay, college playoffs are over, so we're back to business. Seriously, though, that's actually something I want to talk about this morning is a lot of things that happened to me over the weekend, questions that I get, things that popped up in my real estate business. So we're going to run through some of the basics this morning. One of them is your favorite. We're going to start out on the serious subject. Hopefully we can lighten it up from there. What is a quiet title anyways? What does that even mean?
I knew you were going to ask me that.
Do I have to say it like this? What's a quiet title?
Yeah.
Okay.
Yeah, you can't say it very loud. Okay. No, it has nothing to do with the volume.
Okay, well, darn. That's kind of what I thought I had it.
So quiet title is a method that a lawyer can use to fix a title defect.
Only you can use it?
I mean, anybody can do it, but it's complicated.
Okay,
I mean, it's
so
not a simple procedure.
But it's not something like, can a title company also do it? Okay,
no.
so it has to be done through an
Well, I
attorney.
mean, a title company can't do it just because they can't represent somebody pro se. They don't have a law license. But an individual that had a title issue could do it themselves if they wanted to.
Pro se.
Yes, but it's...
That's a fancy term for representing yourself.
Yes, it's complicated.
Who's the lawyer now?
Yeah.
I'm just kidding.
Do you know what language that is?
Something from the bar exam.
Yeah, uh-huh.
Okay.
So
Latin.
there you go.
Thank you.
Pretty much all legal terms are Latin.
Okay.
They're not all Latin, but pretty much all of them.
You didn't think I knew that, though. So
No, I didn't.
What if I would have said pig Latin?
I'm impressed.
Thank you. Okay, so moving right along.
So here's the most common scenario. The most common scenario is where an investor buys a property at a tax sale. Well, when the tax commissioner, do you know what I'm talking about with the tax sale?
So this is when taxes are owed and the property...
Real property taxes in Pulaski County, Arkansas, you can actually be behind 3 years on taxes. And when the fourth year rolls around where you're 3 years behind, they do what's called the tax collector and the treasurer will do what's called certifying your property to the state. They will send an actual certificate that says your taxes haven't been paid, they're delinquent for X amount of time. We're certifying that to the state for sale.
And that's how it gets into the state land commission.
Correct.
Bank.
And
Okay.
so the state land commissioner will then take that certification and they will go auction the property. And the minimum bid to buy the property is the taxes. Whatever the taxes,
Right, whatever's
fees,
owed.
and penalties are that's owed, that's the minimum starting point, and bids go from there. So let's say that you have an investor that buys that property, and then they turn around, hold it for 6 months, a year, whatever it may be, and they sell it. Or they develop it and sell it. There's a lot of different things that you can do with that piece of property, and it's very common that you'll have a lot. Like an empty lot will be a property that's commonly sold because the taxes are so cheap.
Well, and it's just like now you're dealing, when you start even talking about the possibilities, you could do anything with it.
Yeah. And so you go to sell this property, you get your title commitment back from the title company, and they say you're going to need a quiet title because you bought this at a tax sale. And the deed...
It's like, I got a good deal.
Yeah. And the deed that the commissioner gives you is a limited warranty deed. So they will limit...
Not like our special
they will
warranty
limit,
deeds that we...
Correct. They will limit their deed to whatever they gave. And so there's no guarantee, and I've seen it, where the tax will certify property in the name of an owner who's not the actual owner because it'll be a joint deed and they'll only put one name on it.
Okay,
and
so
they'll screw
also
up.
that brings up a good question. I mean, for me, it's a good question. When you're working through this process and you're going to court sales, you actually are not getting the full abstract and or a title work done. You're just going in and buying it blindly, right? So you don't have an abstract history of the property. So I guess what happens when it changes hands, you're talking about none of this was previously disclosed anyway. So this party in the middle says, I'm not going to warranty anything except for what I know.
That's right.
Which is that the taxes are due and now you own it.
That's right. I mean,
That's dangerous.
It is as is, whereas the state would be the party transferring it to you. There's nothing you can do.
That sounds
so
terrible.
you're buying a property just like it sits.
So it also has to be something that's not at risk. So vacant land makes sense that this would be really common occurrence because there's probably not a lot of risk with vacant land. You don't have to inspect it unless you're looking for utilities.
You could have some environmental problems or something like that. But yeah, in a residential subdivision, vacant lot, usually there's not a lot of risk there.
So tell me kind of how this happens most often in our industry then. Like when a quiet title issue pops up or when someone calls you like, hey, I need a quiet title, like what is the problem that that quiet title solves?
So when you go forward, so at this point, the title company is going to tell you, you don't have good title, you've got to do a quiet title. And that's what it solves. A quiet title is a court order. It's actually a decree of the court.
From the judge?
From a judge that actually says, you are the owner of the property, and the entire history of the abstract, the property, all the way back to the beginning of time is now vested in you. It resets the timeline of the property.
It's all irrelevant.
You're the owner. It doesn't matter who's owned it in the past. Title companies look at that and they love that. They find a quiet title decree and you can stop right there. It's done.
Because once they have that, that means that the history of the property is erased except for the owner that currently owns it.
That's
so
correct.
unless it changes hands again,
that's
you're
exactly
good to go.
right. And so where there were previously questions about throughout history, was title always transferred correctly? Through the tax sale that we've discussed, was title transferred correctly? And it doesn't matter at that point whether it was or not. And so you actually have to go in as a plaintiff in a lawsuit, and you have to name as defendants any prior person that might have an ownership interest in the property. So it's an actual lawsuit, and you say there's all these things you have to do. All the this one has a lot of squiggly lines.
All of the lights in my head are going off right now because this will blow your mind.
Yeah.
Expert testimony is one of those things where you go in and you're an expert at what you're an expert at, right? So if I go into a court case, I'm not necessarily going to know exactly all what's going on. I'm going to know the questions that I'm being asked. So I've definitely testified in quiet title.
Yeah.
I'm just now figuring it out because it was like they went through all the names.
Yeah.
Yeah.
So squiggly line, there's a lot of them in a quiet title and things you have to do. That's why I say it's complicated. It's not easy to do for anybody to walk off the street and say, I'm going to quiet title to my property. And so you go through all those steps and you basically say, former people that had an ownership interest in the property, y'all don't have it anymore. It's in my name now. And there's these different notices you have to send out, things you have to publish in a newspaper. You have to actually place a sign on the property.
Let people know, like if this was owned by your family or if you knew something about it.
You publish a notice that says, here's the court date. You either need to appear in the case before by filing something, a response or an objection or an acknowledgement, or you need to show up at court.
Which that means they could drag it out for a long time because you have to get in touch with a lot of people too. So it all depends on the actual abstract of the property who you have to reach out to.
I usually turn these around in 60 days or less.
Yeah, but you're bad to the bone, so that's a little bit different.
But yeah,
that's because you're Kendall Grooms and you sweep it right up.
We've done enough of these now that we have a process that we do it by. And
you
it's
don't like it when I
court-dependent,
come
too.
up with little sayings for your name?
No.
Okay, continue. You have do what?
We have just a process that we do.
Yeah.
That has conformed with the code, and it's different than how a lot of people do it. A lot of people still want to go through and do what's called a warning order, where they publish. So in Arkansas, we have what's called Rule 4, which is the rule of how you serve papers. Like if you file a lawsuit and you get a summons and you have to get a process server to serve it, the Arkansas Quiet Title Statute, there is no Rule 4 application. It sets its own standards for how the documents are to be served.
So you technically don't have to receive that certified letter or by signature.
Correct.
To acknowledge it. So that's
for the
why,
notice to be given under the quiet title
So as long as
statute.
you give the notice, I'm guessing there's a time period.
Yes. And so what you have
Always
to
with a
do,
time
it's
period.
crazy actually what you have to do. So let's say that you're the former owner of this property that I've named as a defendant. So it's Jamie Taylor. So I have to find out what your last known address that I can find somewhere. And what I have to do is I have to send a certified copy to Jamie Taylor at that address, a certified copy to occupant at that address, a regular letter to Jamie Taylor at that address, and a regular letter to occupant at that address. And so that is to assure delivery of at least the non-certified letter to that address, because the occupant one will not be returned for someone not being there.
It's like $1.28 in postage every time.
No, it's more than that. It's like almost $20.
Because you have to do certified. Yeah.
It's almost
So
$20
I was going to
per
say even just
person.
mailing
And
it.
we just had one last week that Jane mailed out 88 of them on.
How do people, and that's the thing, like but it's very important because it's a situation where like somebody could potentially, let's say my son is named in my will and testament, which I have questions about as well.
Yeah.
And he's going to get my property and then he's not around when I die and it goes to the state because the taxes don't get paid and somehow he just didn't know about it and then he comes
That's
back
the
and
most
figures it
common
out.
reason why property gets to the state right there.
Well, you know.
Yep.
So he goes through and he's looking in there and he goes, wait, I own a piece of land. And then he goes and finds out like, oh, well, it's already been sold a bunch of times. So the only way to really would also be to bring the will and testament and then also to go
If it's
through.
already been sold a bunch of times,
Did I
it's
just say
over.
that? Yeah, okay.
It's over.
The right thing to say, will and testament?
Because if your property gets sold at a tax sale, you only have a limited amount of time to
claim
redeem
it.
the property or it's
Okay.
gone.
So it's
Yeah.
the redemption has a statute too.
Correct.
And every
It's
state's
now
different.
30 days in Arkansas. It used to be a year.
Well, the market's appreciating, so they're trying to react.
There's going to be various times, but in all kinds of states about what that redemption period is.
Okay, so everything's different. It's not like a nationwide thing. Just look up your state law.
Mm-hmm.
Okay. Well, thank you for giving me that very riveting lesson on quiet title, and definitely reach out if you have any questions about that. But here's my next question, because this is something that, like, I'll be totally honest with you. Like, you're my lawyer, and so this is kind of your fault. But, like, I don't have a last will prepared, and I don't know why. I think it's because I have a good feeling I'm going to live forever. But I want to know if somebody dies and they don't do that, like if I die tomorrow and I don't have any plan for like where my house goes to or where my property goes to, like what's the actual realistic thing that happens with your property? I mean, other than the option of, okay, you didn't pay the mortgage or you didn't pay the taxes and it goes back to the state or it goes back to the mortgage company. Yeah. What if both of my kids get into a fight about it or my husband and my mom get in an argument? Like what happens?
If you die with no will, it's called dying intestate is what it's called. And it's different from state by state. There are 13 states that are community property states. Arkansas is not one of them. Texas is one of them. Several of the West Coast states are community property. It means any property that was acquired during a marriage.
Common law property is prevailed in Arkansas, right?
Yes.
Okay, but what if I'm not married? Now I'm not married.
I'm saying though, if you're married, pretty much all, there are exceptions, but pretty much all of your property that was obtained during the marriage goes to spouse. If there were things that you brought into the marriage, then those can be handled separately. So, but we'll focus on Arkansas for this purpose. It's what I'm licensed in Texas and Oklahoma, so I know a little bit about it from Texas, but Arkansas follows the majority. There's the other 37 states.
We're also the best.
Yeah, it's correct.
Sorry, go ahead.
But Arkansas, 2/3 of your property would go to your children and 1/3 would go to your husband. Now, there's some exceptions to that of certain pieces of property may entirely go to your kids. I mean, that's a really hard question. I'm just thinking of like
the responsibility level of that too.
But there's some things that the spouse would get a life estate in, which means at a later time it would revert back to the kids. If you have income producing property, the spouse may get a lifetime interest in that income producing property where they would get 1/3 of the income, but not an actual interest in the property.
How does any of this get determined though? Like
through a probate proceeding.
Okay, so it goes to probate.
Black letter law in the statute says how all this is to be divided if you don't have a last will.
Okay, so there is a plan. All right, cool. Well, then
what about... It can get pretty messed up in Arkansas if you have a situation where you have like a second spouse. Mm-hmm. So it's stepmom or stepdad to children that not second spouse.
I know
like
you meant secondary. I was like, that's not legal
not
here. This is not Utah. This is Arkansas.
Like second, like one spouse passes away, you get remarried. So now you've got like stepmom or stepdad with grown children, no will. All of a sudden you have grown children that acquire an interest in property after somebody dies, who own a joint ownership with a step parent, and you can imagine.
That's fun. I bet that's really fun. That's going to be a great... Actually, let's find one of those to use for the next episode and we'll...
Oh, I have one, but it's a pending case. We can't talk about it
All right,
now.
Close it up and let's use it for I Hate Real Estate because okay. I tell you what, working with family will make you hate real estate no matter what. It's just part of it.
That's the most common situation in a probate when people fight is when you get a step parent and children involved.
Well, what about if they die like... What if I die mid-deal? Like, what if I'm under contract on a complex right now and I'm about to close the deal and I'm 10 days away and all my financing is done and all the lending's done and like, or maybe it's cash. This way the lender isn't. Good.
Got a visitor.
The lender is, hey there, John. I'm like, I'll call you out. It's fine.
That was Don Campbell, ladies and gentlemen.
Yeah, that's the other partner. That's the big boss. He doesn't like it when we're in here playing. No, I'm just kidding. You're the big boss.
He's here to work, I guess.
He's here to work.
On a holiday.
On a holiday. I just would like everyone to know that's watching the show. Oh, wait, they're entrepreneurs. They're all working. Yeah. They're listening to this while they work. So anyways, mid-deal though. What if I'm mid-deal on an apartment complex? I am cash, so you don't have to worry about that. I'm about to close. My title work's done. Everybody's happy. Seller's happy. I die 2 days before closing. I have no plans for how I want this to go. I am not married. I don't have children. What happens?
So if you are doing the deal individually, like if it's Jamie Taylor is on the contract, that contract terminates upon your death.
What if they don't know I'm dead?
Now, if you file a probate case, you have the right to request various, or you don't, but your people handling your estate have the right to request to continue business operations, things that need to be done, finalize that contract, whatever it may be.
Like someone could come and be like, she meant to buy
all of those scenarios are covered in the contract of what would happen in the event of a death, the termination of the contract, all of that.
Well,
should be at least.
Well, I mean, my big thing is and I'm just more concerned about from the will and testament side. And the reason I ask that is because I think a lot of times when people get into the business, and it's just me, I'm a perfect example. Like, I've been in the business for a long time. I also know the risk of, like, you know, I could die tomorrow. Nobody knows when their time comes. But I didn't ever think to plan it until recently. Yeah. And I was like, wait, Joey goes, will you meet with an attorney like every Monday morning? Why don't you just talk to our attorney about this? And I'm like, oh. That's a really good point. I'll do that on Monday.
Well, if you have a commercial deal under contract, in all honesty, you should have it under contract in some kind of registered entity, whether it be an LLC or a corporation. And the LLC is not going to die, obviously.
That's kind of was wondering.
Or a trust, whatever, some kind of entity or instrument out there that creates an LLC, a trust, or a corporation to be under that contract, then that doesn't pass. Whoever would be the owners of property and how they would pass within your probate case is who would obtain the controlling interest in the LLC. Because that membership interest passes through probate. What just
played through my mind too is like, okay, in my LLC, if I own 50% and 50%, normally those decisions have to be voted on and executed through special meeting minutes or whatever. But if you're in a situation where one person dies and the operating agreement of the LLC transfers interest upon death, then that person becomes the majority owner, can sign for the contract and close the deal, and it wouldn't matter if I'm dead or alive.
Technically, an operating agreement can't transfer the ownership interest at death. But
here we go with a bunch of legal jargon.
It passes by operation of law. The moment you take your last breath, the probate process just formalizes it.
Okay, so it just makes it official.
But you'd have to take steps in the probate case to finish out closing on that property and complete that contract.
Yeah, which would upset that seller because it would take a lot of time. So, okay, well, there's the answer to your depressing question.
It actually doesn't take a lot of time either, though.
Those are the depressing.
I can get somebody appointed as a personal representative to be able to handle that within 30 days. So it's not like a year long or a 6 month long deal to get it done.
Yeah, that's another good thing about Campbell and Grimm's law firm.
I mean, anybody can do that, but some people just, I don't know why it takes a long time to do probate stuff somewhere.
Well, in probates, it's never a good situation. There's always questions about what happened. There's always emotions. There's always family member involved. So probate's never been an easy thing for me. Yeah. I think the easiest one was the most complex one that we ever had, which was weird.
Now, Arkansas recognizes something differently with respect to spouses as well. And a lot of people don't know this. If you own property in Arkansas jointly.
Yeah. Oh, tune in for this. This is crazy in other states.
Yeah. With your spouse, it automatically passes outside of probate 100% of the interest.
Not just that, but when they try to get divorced, it's like, oh, no. You live together and this is a common law state. We're going to decide what happens to this house, even if you bought it before you got married. And even if you brought it into the marriage, unless you sign something that protects you like a prenuptial agreement, you will be settling that 50-50 with your spouse or however the attorneys
most courts
figure it
here
out.
will just order it sold.
Crazy.
And the net
which is smart
split.
Because then the real estate business...
Yeah.
Sell all the houses.
But that's, I mean, any jointly owned property owned by a husband and wife passes outside of probate. So that doesn't have the same application. Bank accounts are the same way. Vehicles are the same way. Houses are the same way.
That's not good. Property. If I died, Joey would be so mad. He'd be stuck with that Forerunner.
There you go.
Okay. So those were the depressing sort of quiet questions of the day. And this is what I'm going to do when we don't have a case to review. We've talked about this before the show and on other episodes. We've got plenty of things to cover. So if you guys have questions, please reach out and we will address certain scenarios that have happened to you. If it's outside of Arkansas, we may not know the law related or the real estate practice related, but we'll do our best. So moving right along, let's talk about some things that happened to me this weekend.
Okay.
What happens when a tenant changed the locks on an apartment and you have no access to the apartment? It feels like they nullified their lease, but I can't exactly find a sentence in the lease verbatim that says if you change the locks, you have nullified your lease.
Does the
management agreement says that they need to have...
Does the lease provide for the landlord to have access at any point
within
in time?
24 hours with notice?
Has any notice been requested?
48 hours notice, and then we showed up, and I knocked on the door, and they didn't answer, so I tried all the keys, and they didn't answer, and so then I'm like... So I go around, and all the other keys work to all the other doors. Well, then...
It's a simple breach. I think I went
back the next day. Well, anyways, it's a breach, but it's like, so here's the question: Can the management company just go on in there now and rekey it? Leave them a key? What happens?
I mean, I wouldn't do that if it were me.
Well, what do? You have no idea what's going behind that door. What if? Okay. I have a client that will be calling you this morning about a lock that he can't get into.
I mean, unless you have an express right to entry in the contract.
So that's actually the answer.
Not like a 24-hour notice that we can get access, like something that actually says we have the right to enter by any means after 24 hours notice.
Okay, so basically, if you really want to be able to trust your tenants and know that they're willing to let you in their house at all costs with 24-hour notice, you need to include a what in your lease agreement?
Just some kind of phrase that gives an absolute right.
But you called it a thing.
Well, I don't think there's a
right of
official term.
Yeah, you just said it. It sounded cool. I was ready. It was a right of entry. It was a right of entry, I think you said.
Yeah, but it has to be, I mean, you can have a right of entry on 24 hours notice. You have to have a right of entry under any circumstances.
That's what it is, but you said it cooler before, so I'll figure that out when I watch this back. So maybe somebody will comment. Yeah. So that's the answer. Okay, now this is going to be fun, and I'm curious because this is going to be a question that I should know part of and you should know part of. But this is something that I've never asked myself or anyone else or discussed with another appraiser. But I had this thought today because I was working with a client yesterday, and I was looking at their house thinking like, okay, what could they do? And one of the things people do is they do construction loans, and they do that on properties that are not in great condition. They add value to them. The ARV becomes the number that they're looking for to sell the property at, right? Well, on the appraisal side, they do something called a hypothetical condition or an extraordinary assumption that they can apply to the property, and based on whatever improvements or changes are going to be made, then the property's worth a certain number. So the actual appraisal will say, this house is worth $100,000 after you do all these plans that you blah, blah, blah. Then it goes through, and this is all analysis and cost and understanding, and a contractor looks at it, and the bank's involved, and all those things. And then it says at the end, it's going to be worth $179,000. So it really gives this investor a great tool, or a homeowner a great tool to know, should I put these updates into my home based on this information? So as I'm thinking about that, I realized, like, what if you're doing an ARV repair and you give the appraiser all the information, and you've had the inspection, and you know what to expect, and you've hired your contractor, and you have your costs, but then you close on the property and you bought the property for $100,000, and your plans to repair $75,000, and you're going to sell it for $350,000. So you're $175 in, $350 out. You walk in the house and you start working on it, and you start digging stuff up, and you start getting into it, and find a major, I'm talking like major ass defect, like warrants a cuss word defect, can't
like you just lost all the profit that you had
gone.
in this house.
It's gone.
Your coffee was almost gone.
I need a drink. So yeah, all gone. But there has been an appraisal done, and the client is a first-time investor, and they're like, oh, this is bull, because I was told on this piece of paper it's going to be worth X, and this is what it's going to cost to repair it. And then there's this massive issue that nobody saw. Wasn't, so no one's at fault.
Yep.
So the house is then not able, because it has incurable repair. So maybe there's a secondary appraisal. Maybe someone does additional analysis. Is there a case here? Like, could there be a case of you didn't give, as a contractor, enough information that this could be, is there something that could fall on the inspector? Is there a case where you've ever seen somebody do a hypothetical condition or extraordinary assumption as to what the value would be afterwards, and then came in with a lawsuit based on the fact that that did not happen?
I haven't seen that, but I have a lot of questions about how it would arise, because it seems to me a lot of that would be covered in the contract.
Well,
about
would it be
what
covered?
Right to inspection was there, or what disclosures were there, what warranties were given.
So this is like a situation that hasn't happened. It's just, it's one of those weird things that happens, with your brain when you're analytical. You're like, oh, this would be a fun, hairy one to get into. And it's because I was thinking, so if you're doing a massive appraisal on one of your big fives, which is your foundation, roof, electrical, HVAC, plumbing, right? Those are your big ones. If you get into a situation where the inspector goes in and he does all of that, and he doesn't find anything wrong, and you have a structural engineer and everything looks fine, but maybe you start working on the house, and the work that you do because of the house that it is maybe causes a major defect that nobody saw and or didn't warn for. And I guess that's why I'm looking for what. And that's where it comes back to
what was disclosed. Did you disclose fully engineered plans, architectural plans, any of that kind of stuff that you were doing on the property, or the scope of work, where if an engineer had analyzed it, they should have considered the scope of work, a load area that you may have been changing, something along those lines. So, if somebody misses something when you gave them that appropriate information, you might have.
So your lawsuit almost would be based on the scope of work of the associated engagement agreements related to
factually intensive. Yes, it would be a fact-intensive case, document-intensive case.
And it would be
because you find something bad in the property that you bought after you start working on it automatically means you have a case. There have to be some other extenuating circumstances.
And I guess the reason why I thought this could occur is because I'm thinking about people who are moving into our area that are doing a lot of updates and stuff. And I think because particularly I was in an area of town that I questioned myself on the street I was on, because I'm not Tony Curtis, who's like downtown, king of downtown. I don't know the streets all, but who's in the historical district, who's not. I have to look it up. So when I pulled up, I thought to myself, like, that's another thing right there. The costs associated with the time and the energy to go through historical district permitting when you're going to make updates to property is another thing that what if it wasn't mentioned in the conditions or the assumptions applied on the appraisal? And then that's a loss of disclosure. Like, is that the seller's fault for not telling you that cost was going to be associated, or your fault as a buyer for not doing your diligence? Point is, all of this being said makes me want to say to an investor, like, this mitigates your risk, this whole appraisal thing. But really it comes down to, I think, the addendums associated with the inspector you hire, structural engineer, contractor.
And it comes down to preparation too. You need to be able to say, here are all of the plans. This is exactly what we're going to do.
And you show them the plans, I see.
And you can't tell some engineer, hey, I've got $500 to spend for you to analyze this for me.
Yeah.
I mean, you can't, if you're limiting things like that on the scope of what you want to be done or want to be looked at, then you're on the hook for it if you don't get a full and complete report.
Well, I want people that don't understand, first of all, if you don't know about that kind of appraisal, that's a really, I just think it's a bad mamma jamma. It's really cool. It's like, take the property and look at it right now. What does it look like? And then you justify the future sales price based on market conditions and forecasting of those conditions and all that. So it's a really cool appraisal. And I'm curious. I'm curious if I said it out loud now that I'm going to cause that case to come through your doors. I hope I do, because I want to testify in it. Moving right along. So commission write-in, did something this weekend. I don't think I did anything wrong, because I don't fill in the blank.
You got a complaint filed?
No.
Oh.
Fill in the blank. Oh gosh, no. I would be in here crying. I wouldn't be on the air. I would be like, let's go in there so I can cry. No, it was a commission agreement. And it's
I thought you were talking about the real estate commission.
No. I love them. They're nice people. We get along.
But you don't want to be in front of them.
Don't want to hang out with them. Mm-mm. They're just like they're like family members who live out of town. I love you. I just don't want to hang out with you. Kind of like that. But when it comes down to writing in your commission, this is not the unauthorized practice of law, because this is the execution of your agreement with the seller. Correct? All right, cool. I filled in the blank. Just making sure.
Yep, that's why those exist.
I know. I was just making sure, because as I was writing this in, I'm like, wasn't that podcast we talked about never fill in the blank ever?
Now,
but this is my money.
No, if you started doing all kinds of contingencies and stuff with respect to your commission, like, then I could see it being a problem. But you do see people all the time. Like,
there is contingencies involved.
Especially in commercial deals. You see contingencies all the time about that it'll be X percent, and if a certain event happens, it'll be this percent. You see those. I don't have a problem. What event, I don't have a problem with that either.
Yeah, it's usually an event related to procurement of an additional party in the transaction that increases or decreases your...
Correct.
That was a good way to say it. So
if it's simple, but if it starts getting really complicated where you're like adding pages on the back, that's a problem.
Yeah, and then if I show it to anyone who has a dog in their car and I have to do it for a short period of time, then it's going to be, less commission because I didn't put as much work. I mean, that's a lot. Okay. Well, that answers my question. So getting ready to wrap up the episode, one thing I really want to do from now on is I really want to start sharing something positive, because it is the I Hate Real Estate show. And there are some days I really hate this job. And I'm sure you do too. But there's some good things, and I'm going to share one with you today.
Okay.
I listed a new property this weekend, and it had a crawl space to die for. And as a listing agent, I've never seen anything so beautiful. And I want to tell you that as your friend, I know
there are no beautiful crawl spaces.
Oh, candle. I went to the side of this house. I'm measuring it. You're not even going to believe it. You open a crawl space and you're like, okay, here comes the insulation and the spiders and the web and the dirty ground.
And I'm going to be crawling in a creek that's running under the house.
No.
It was white and pristine.
White.
Yeah.
White. Pristine visqueen across the thing. Humidifiers lined up by the concrete block. Okay. I could go to sleep in there.
Have some
dry,
pumps
huge,
running.
brand new water heater that was massive. I mean, I opened it. It was a roll door too.
Wow.
I opened it and I just went. I stepped inside.
Was it like 8 feet tall where you could stand up underneath it?
And my assistant is like getting her real estate license so I can teach her how to do this. And she's like filming the measuring part of it, And so I like open the door and I just kind of get emotional. And she's like, what? And I'm like, this is every listing agent's dream. Like, this is a beautiful house in a great neighborhood. And I got no problems with my crawl space.
Except when they have to disclose why they did all that.
Except for, here's the other hopeful part of the story. I'm like, you need to disclose everything that happened because clearly something happened.
Nobody does that just because.
There are good people in the world. They just don't sell their real estate. So, but I literally looked at this and I called the seller and I'm like, I would just like you to know, sir, that I'm impressed. I've never seen one like this. I'm very proud of you. It's an honor. And he goes, well, I learned some lessons. He's like,
bet.
that's not how it was when I bought it. I'm like, okay. He's, what do I put on the disclosure? I'm like, everything. And he almost says it like in conjunction. Everything. I'm like, everything. Every dime, every dollar you spend, everything that you did. Because first of all, everyone's proud of you. Good job. And secondly, we want to be in a position where the buyer knows exactly what happened. They know what to keep an eye out for, and they know how to maintain the systems that are now in place. But the hope that I bring to you is that it is so nice when a seller accurately discloses an event at their house and then adequately repairs the issue, and then they're honest about it when they sell it. So there's hope for us yet. Just wanted everybody to know that. That's the hopeful moment of the day.
It makes the fair market value very easy to obtain.
It puts the fair in the fair market value,
right.
my friend. So thank you for your proper disclosure, new client. I'll sell your house today. What about you? You got anything exciting and hopeful?
Nope.
What's Don to Don doing out here?
Nah, he's working, I guess.
Sounds like he's working.
I know he's meeting people out there.
Let's go investigate. We're going to go investigate.
Maybe that's positive. He's out there making some money.
Yeah, well, let's join him. We'll log off and make some more money, and then we'll come back next week for another episode of our favorite show. If you have not subscribed yet, smash that button, and don't forget to look for us on Facebook, Instagram, and anywhere else you can find a bunch of haters. Thanks, Kendall. It's been great.
Thank you.
We hate real estate. See you next week.